So good evening, everyone, again, and thank you so much for joining for the CDSPI webinar, A Malpractice Survival Guide. My name is Andrea Medina Vera, and I'm an early career education specialist at CDSPI. My role focuses on supporting dental students, new dentists, and the broader dental community through educational programming on insurance and risk management strategies tailored to the unique needs of the dental community. If you went to PDC or the ODA ASM this year, you may have noticed this session on the agenda. The response was overwhelmingly positive, and because of the level of interest, we wanted to make this information available to dentists across Canada. Before we introduce our panelists, let's take a look at what we'll be covering tonight. We're going to spend the first hour in a moderated panel discussion with our experts covering key themes around malpractice risk, prevention, and what happens when claims arise and what you should and shouldn't do. And with that, I'd like to invite our panel to introduce themselves. Maybe starting with Dianna and Kris.
Good evening, everyone. My name's Dianna Robertson. I am a managing lawyer here in British Columbia, in-house counsel with Zurich, and I've been with Zurich for almost 5 years, and probably 80% of my defense caseload is dental negligence.
And I am Kris Milland, obviously also in British Columbia with Dianna. I am a claims manager at Zurich, so I manage our financial lines team. They are the ones who take in the claims and help our dentists figure out what's going on and retain people like Dianna to defend them.
Hi, everyone. My name is Julie Berthiaume. I'm the Senior Insurance Advisor with CDSPI, located in our Toronto head office. And so I work with dentists across the country. I've been with CDSPI for over 20 years now. So I'm happy to be here tonight with you.
Getting started right into the content, it may have surprised some of us to see that the complaints due to misdiagnosis and miscommunications continue to lead incidents. This is why we want to begin the conversation discussing the why malpractice claims happen, how to avoid them, and knowing what to say and not to say, because this can really make or break your prevention plan or defense. So starting with our first question for Dianna, let's say a patient complains about an outcome and hints at legal action. What should you do immediately?
The important thing is to document in your clinical notes what the complaint is, what the patient's concerns are, and the moment you have any indication that there could be a claim, you should reach out to report a potential claim. That doesn't mean it's ever going to turn into a claim, but there are things that services and assistance you can get through your insurer to help you navigate that communication going forward with the patient so that you don't make any admissions, make any, say anything that would come back at you later as somehow an acknowledgement that you'd been negligent or didn't get consent or anything like that. You would continue to treat your patient, though. You don't want to just fire your patient and send them out the door the moment they have an issue. But you want to make sure that you have kind of advice behind the scenes as to how to navigate that issue.
Yeah, I think reporting it to your broker is as important as documenting, right? Those are the two things you should keep in mind. We can provide you with legal advice if necessary at that point. We can tell you what the coverage will be if something goes wrong. Mm-hmm. The one thing I really want to say is offering a refund is not the best course of action right away. Get in touch with us first, and then we can talk about it.
I believe that the college has some, in BC here, they have some type of a release document that they have, that, when dentists here in BC are having a concern and a patient's asking for a refund, they have a release document. Yeah, Kris is going, no, yeah. The challenge is what, in the eyes of a judge or a jury, offering a refund has a look of acknowledgement that you've done something wrong, even if it's coming from the right place. So what I have seen is where dentists have said, hey, well, let's get you to a specialist, or let's get this looked at further, or I will I'm going to waive my fee, like as a courtesy discount, I'm going to waive my fee. Offering like a courtesy discount or offering to, rectify something without any refund has a different flavor to it.
Absolutely. Yeah.
And I wouldn't have any concerns about that. Because you have to deal with your patient satisfaction and you don't want a bad Google review and all of those other things. But just, offering to give all their money back doesn't usually go well. Yeah, it usually emboldens people to think that they actually have a substantial claim, because why else would the dentist give me my money back?
Yeah. It also sets the floor for where we can negotiate from there. If you've already offered them $30,000 back for a mouthful of implants, right? We're starting at 30. You can negotiate down, you can try, but it tends not to go well.
And this is more, I was going to say one other thing, and it's not within my wheelhouse, but it is my understanding that often refund is not covered as an insured benefit.
Yeah. So we don't pay for refunds. So if you offer a refund, you're on the hook for that. And in fact, if we then settle later and you've offered $30,000, we didn't consent to your original refund. So it's likely that $30,000 will be yours to pay out of a settlement, and we'll just be paying what's over that. So definitely don't is the advice I would give. Don't offer refunds.
Thank you so much. And then Kris, back to you. If there is a misdiagnosis, how should a dentist approach mitigating the risks of escalation?
Contact us. That's it. It's the same answer. Get in touch with your broker, get in touch with us. We'll have a chat. It ends up being very fact specific. What went wrong, right? Was it your problem? Was it your hygienist problem? Was it the clinic you worked for's problem? Was it actually something external? Is this person dealing with mental health issues and the whole thing is made up? It can be so different depending on the facts. But if you get in touch with us, we can talk through that with you. We've had hundreds of these claims. We've seen what's happened. We can give you some advice on next steps.
And I think also it's important for the dentist to remember that even if there is a misdiagnosis, that does not necessarily mean there was negligence, because it's, in hindsight, in 2020, hindsight is always looking back and saying, oh, that wasn't diagnosed. But the test is what you knew at the time and what you reasonably, using your clinical judgment and testing, what was the reasonable diagnosis or procedure to recommend. And you're only going to be held to what you knew at that time, not later on when it comes out that, that the diagnosis was not correct. So don't panic if there was a misdiagnosis.
Excuse me. Thank you so much. And then this one is for all of our panelists. What documentation habits separate dentists who successfully defend claims from those who struggle, even when care was sound?
I think all of us will probably have very similar answers to this. Document. It just, like it was already kind of reiterated, you put everything down on paper, make sure your charts are detailed, they're clear, they're legible, because not everybody has fantastic handwriting. If they're electronic, even better, and make sure that your staff understand what your expectations of documentation are so that they are doing the same that you are doing.
And one of the things that I have come across a few times, and it, especially with the electronic documents, is that dentists will forget to sign off on that electronic document the same day. And then, weeks have gone by, and I've had this on a couple of files where then the big problem arises with the patient. They're panicking, and then they go in and they sign off on the chart note. And again, they may not have made any change to the chart note, but the look is, oh, we're trying to backdate and cover up what wasn't charted. And I've had that a couple of times where the tendency is to then chart it, late, nail it down. But of course, with the electronic charting, it's very clear as to when it was signed off. And if you make any changes to that, then it's all noted in the system. So make sure that you're checking the charting and signing off on that charting, at the end of every day. I know it's hard sometimes to do it after each patient, but making sure you do it at the end of the day. And also, I think charting if you have complications, if it is a difficult extraction or a difficult procedure, chart it. Don't shy away from charting the problems that arose. Because if you chart, patient was good, everything was fine, and clearly it wasn't, that's going to, in terms of charting, look just as bad, right? Because then you're not accurately charting the complications. And again, complications do not necessarily equate to negligence. It just means things didn't go as hoped or anticipated.
And as mentioned, I think my big point is electronic.
Yeah.
It needs to be electronic. So if you do hand notes, that's fine. Just you've got to scan it at the end of the day and put it in a file, a secure file somewhere on a device, because that is unchangeable. Once you've done that, we can tell if you alter that file. So we can say this happened on this date, and as Dianna said, it doesn't look like you tried to change it later. Whereas if you have a physical piece of paper, it can be replaced. You could write something new on it, that sort of thing. So if we have a timestamp, that's way better for litigation than if it's just paper in a file. And there's no veracity to that.
Way back in the day, it's not a dental file, but back when I was doing plaintiff work, medical negligence, I had a file where we were able to show, I was on for a plaintiff, that a specialist doctor had gone back and added notes to her handwritten chart because she used a slightly different pen color.
Wow.
So people do try to go back, and that's worse than just not even having it noted.
Yeah, exactly.
Thank you so much. What about when it comes to dental clinic staff? They communicate with patients more than the dentist. Is an associate dentist or practice owner liable, and how should a dentist involve staff in prevention?
I want to take that.
I mean, as far as our perspective, we're looking at an employee-employer situation there typically. Dentists are independent contractors, whereas dental hygienists, receptionists, whoever, are often employees. So is the clinic operator liable? Yeah, through vicarious liability. And that's true of any employer-employee relationship, where your employee is in the course of work and does something negligent. You are responsible because you didn't supervise correctly, you didn't provide them the right training, whatever it may be. So yes, you when you have staff, you must supervise and train them. It's the same thing for the dentist often. The dentist can be responsible vicariously for the actions of people working with them. So if you have a hygienist working on a patient and it goes wrong, you could be looped into it. Now, sometimes you get looped in no matter what, even though you weren't involved, you never saw the patient, et cetera, then we get you out. That's our job, right? But and I'll let you speak to that. But if you were instructing them to do something and that caused a problem, for example, you instruct the receptionist to provide your client with a bottle of tooth whitener, and they give them a bottle of etching gel that destroys their teeth. You could be on the hook for at least a portion of that because you gave the instructions but did not supervise the transaction.
And ultimately, the health provider is responsible for their support staff. I think, there is a bit of an exception when it comes to associate dentists, although often the clinic is named at the beginning because plaintiff lawyers, one of the things they need to do, and they rightfully should do, is spread a wide net, because it's easier to let parties out than it is to try to bring them in later. So often what we'll see is there's a few different dentists and all the dental corporations named. And then once we are able to say, oh, well, actually, here's the associate contract between the clinic and the dentist. Clearly, this is an independent contractor. They're responsible for their own practice. They see their own patients, and they're at no time supervised by the clinic owner. Then often we can get the clinic owner out. I think the exception to that is where we have a situation where the policies and procedures or the equipment that are owned by the dental clinic are the problem. So if there's some kind of systemic policy within the clinic, or if it's an equipment malfunction, that leads to an injury, let's say, for example, burrs on, to do root canals, and the clinic says, we reuse I'm just making this up, but, we reuse those burrs, 100 times. That's our policy. Well, they would, and then it breaks. Well, the associate dentist doesn't order in those burrs, and,
Exactly.
they're not fully responsible. So there are some situations where the clinic can be responsible in addition to the associate, but generally we can get the clinic out.
Yeah.
Thank you so much. And then this question's for all the panelists. What are some of the most common misconceptions when it comes to malpractice and malpractice insurance?
Okay, I'll jump in here. So often dentists don't understand necessarily what a deductible is, but just like you would have on your home or your auto insurance or anything else like that, it's what the portion of the claim that you are responsible for before the insurer will pay out any settlement. So it's basically the risk that you're taking on. Another misconception is they don't understand that the malpractice insurance policy is not just there to pay any settlement awarded, but also to cover the legal fees involved in defending you. So this is, obviously a large cost that you don't necessarily want to bear yourself. And another big question I get a lot of the times is dentists will inquire whether their malpractice policy will cover their staff. And this is a yes and no question. So if the staff member if the staff member and the dentist are named in the same lawsuit, then yes. But if it's just the staff member named and not the dentist, then no, the dentist malpractice policy is not going to respond to cover the staff. And this is why we actually offer a staff malpractice insurance policy very economically priced, just about $120 a year. So it's strongly encouraged that staff have their own malpractice, because even if it is covered by yours, then it's a tarnish on your record, which nobody wants.
Yeah, absolutely. I think some of the other things I see are college complaints.
Mhm.
So that's not something your policy covers. So sometimes a claimant will bring a college complaint and a lawsuit. We can help you with the lawsuit. We can't help you in responding to the complaint. Another question I get is, when all this is said and done, do I have to report this on licensing? I think that comes up later. That's a thing that we don't deal with as well under the policy. So if any regulator comes to you, that's not going to be something we can deal with. Also, another misconception is about exclusions. What is included, what isn't included in the policy. Again, this is fact specific, but things like fees. So anything where money goes in your pocket, you just give it back. That's how that works. So if there's reimbursement of fees, we don't pay for it. The other thing is punishments. So punitive damages, aggregate damages, multipliers, that sort of thing, where the court is intending to teach you a lesson for doing something wrong. The other thing would be human rights. There's potential there as well. We aren't legally allowed to pay for punishments, because if we could pay for punishments, everyone could run around and do whatever they wanted to everybody. Sorry.
I was going to say, aggravated punitive damages are for like really egregious behavior.
Yeah.
The courts are very clear. It's a tough thing to establish in court, but it is where the behavior is so high-handed and arrogant, and kind of mean-spirited, that they determine that the defendant should be punished either by aggravated or punitive damages.
Exactly. So we can't pay for that if you've done something that's terrible. Same with criminal acts.
Yeah.
Right. Those are the kind of thing we will probably defend you, criminal acts or fraud. But in the end, we can't pay for a fine, a penalty, anything of that nature. Yeah. So knowing what is included in your policy and what isn't is really important, which is what we'll guide you through when you bring us a claim.
And I think just kind of related to that, kind of obviously it falls under the criminal, but there is the tort in Canada of sexual assault, and that it means that a patient could advance a claim under the tort system, which means they have to prove it on the balance of probabilities, 50 51%, as opposed to a criminal standard, which is beyond a reasonable doubt. Sometimes what we will get, I've had a few where there's a claim of negligence or lack of consent for treatment, but then there's also kind of an underlying kind of claim also that the dentist touched me inappropriately or brushed against my shoulder, or these kinds of things. In my experience, if the primary claim is for negligence, I'm defending that, but if we settle it, then we can make sure that release says any and all claims. But if there's a claim that was strictly for a sexual assault, I don't think that would be covered. It's
unlikely to be covered, something like that. So it depends also who committed the assault.
Right.
If it's your staff member, there's a possibility that you have coverage because you're vicariously liable for their actions. But if you yourself, that is the allegation against you, there may not be coverage. So things to be really careful of. Always have a witness in the room. So important.
Thank you so much. But moving on to the next part of our discussion, we want to talk about when and how claims happen. So we learned at the beginning of the session that the average estimated cost for an extractions claim has risen from $22,974 in 2024 to $56,917 in 2025. Kris, can you help explain this increase, and are you seeing this trend in others as well?
I think it's really defense costs are a huge part of it. We're very lucky to have in-house counsel, which keeps our defense costs down. But that isn't true across the board. Not every claim can be done in-house, and so I think the bulk of that amount for an extraction is going to be defense costs. But everything is rising right now. The cost of an extraction is over $10,000 if you want to get it set up for an implant. I know from personal experience. So, the cost of all the things are rising, and that's increasing the overall amount. I think also in BC, certainly we have a real problem with predatory plaintiff counsel. They've come from ICBC, which is now no fault. They can no longer have a practice there, and they're looking for new things to do. So wills and estates and family and employment are all seeing this as well. But med-mal, there are some lawyers who have come and decided this is their new practice, and they don't know what they're doing. And that makes things so much harder for us and complicates our defense and makes it more expensive. So that's definitely driving up costs in my experience.
Yeah, they're taking anything that walks through the door.
Yep.
And that is a problem because medical negligence is good. The good news for the dentists in our audience is that the test is pretty high.
Absolutely.
And to establish medical negligence. The downside is that we're having, at least here in BC, we're seeing a lot of counsel who are kind of dipping their toe into med-mal, thinking it's just like proving negligence in a car accident, and it is a very different thing. So we are actively trying to kind of put our finger in the dike and stop that flow by defending pretty vigorously on those claims that we do not see as having merit, rather than just throwing money at them. So.
I'll also say expert reports are very expensive. And that's also going up in price. And one of the nice things is that they need to produce the expert report, but we may need a rebuttal report. And when that happens, costs start going up. And then we may need more and more. And then by the time you get to trial, you have multiple experts. And, the cost of going to trial is not $50,000.
No.
Nowhere near it, right? So 50,000 is actually one of the better numbers to get as an overall average, because it's the sky is the limit when you go to trial. So that just is evidence of how quickly we're settling these matters, getting them done. But at the same time, turning an eye to the fact that we don't want to persuade more people to do this or these lawyers to stick around. And so we are also making it as difficult for them as possible to pursue claims that are not meritorious.
Thank you. And then Julie, what does being well protected look like for a new dentist, and how does malpractice insurance work? What is and what isn't covered?
Sure. So malpractice insurance, because often dentists will call and they'll say, well, is this particular procedure covered by my malpractice insurance? Well, my answer to that is always it's going to cover you for what you are licensed and qualified to do. So make sure you know what you're doing and not just, winging it on a new procedure. But amount of coverage, this is really a personal decision. Now, we offer anywhere from 3, 4, 5, 10, and 25 million in coverage. Now, the 3 million is sufficient to satisfy licensing requirements, except PEI requires 5. So whether you choose a higher amount of coverage is entirely up to you as to what you are comfortable with, what allows you to sleep at night. Now, obviously, there are some things to take into consideration. So, a dentist who is a specialist, does a lot of surgery, IV sedation, works with a lot of children. These are dentists that likely should have more than just the minimum 3 million. And honestly, the difference between 3 and 5 million is only about $130 a year. So, it's not a lot to give you that little bit extra cushion of coverage. Make sure that if you are incorporated, that you do add the corporation to the policy as well, as it is a legal entity that can be named in the lawsuit. And sometimes you think, oh, most claims aren't going to go into the millions of dollars. And that's true. Most are not. But it only takes one to financially ruin you. Just to put it in perspective, the largest claim that we have on file is over 25 million. So it can happen. Obviously, not every day, and we wouldn't wish that upon anybody, but it can. And just with regards to how it works and retires, this is a big question too. So malpractice is directly linked with your license. So if you hold an active license, you must hold active malpractice regardless of whether you are working or not. However, when retirement time comes, if you do relinquish your license, let us know. We will confirm with the licensing body, and then we will change your malpractice to a non-practicing status. What this means is that you don't pay for it any longer, but coverage does still remain in place for any claims that may arise from when you were practicing, because obviously claims can arise weeks or months after the fact, and you want to make sure that, day after retirement, what if there's a claim, you still have coverage. So just some of those points and how that works, and what allows you to sleep at night. Make sure you have the right amount of coverage.
Thanks so much, Julie. And then I'll hand it over to Kris. Oh, sorry, I
Sorry, just
see.
before that,
Go
sorry,
ahead.
We're just gonna make a comment about coverage and limits. They don't, dental claims do not typically attract a large quantum, but in the time I've been at Zurich, I've had probably 4 catastrophic claims where people have had, abscesses to the brain or strokes, very serious alleged injuries. And depending on the age and the situation with that plaintiff, kind of the worst scenario for one of my clients would be a young person who has a catastrophic injury related to a dental complication, and then will never work and needs extensive future care. Those are the heads of damage that will attract those $1 million plus claims. So if you have an 18-year-old who had their whole life of work ahead of them, and now they require 24-hour care, their care needs, even if it was, $100,000 or $200,000 a year for their lifetime, plus the loss of income, will easily get you into the multiple millions. Yeah. The other thing that I note, because I know quite a few of the plaintiff lawyers who do this work, is when we provide what's called the defendant's list of documents, we need to provide the certificate of insurance. Yeah. So we actually provide to the other side, we redact out how much the deductible is, but the lawyer on the other side is going to know how much insurance you have. And I have seen as a strategy, when a dentist has the more minimal insurance, the lawyer will then make a demand above limits, purposely try to build up this case, even though they may not get it at trial, in order to leverage that we're now putting at risk our dentist's personal assets, their home and other things, as a way to try to squeeze more money out of the lemon.
Yep.
But when our dentist is really well covered,
They don't do that.
That leverage goes away.
Exactly. Yeah, I've seen this frequently across all lines of insurance. They'll do that on purpose because if we, as the insurer, now turn down a settlement offer and the settlement ends up being more than the limits of the policy, we get put into a situation where our duty to the client is in question. Did we do absolutely all we could to make sure that it fell within the policy? And so that's dangerous territory. Now, does that mean we're going to settle at limits? Absolutely not. We will settle at a reasonable amount for the evidence presented. But it definitely, when you have the lower the $2 to $3 million limits on policies, it more often puts us in that position than if you have the higher the 10 and above. We won't see it because they can't reasonably ask for $11 million when it doesn't make sense.
They can't get the numbers.
Yeah, the numbers can't math out.
Yeah.
Yeah.
Oh, and I'll just add on to that because in Alberta and Ontario, you have your primary malpractice through the college, and it's just 2 million, which is actually below the minimum that we offer. So I just want to let Alberta and Ontario dentists know that if you wish to have more than just the minimum 2 million that comes with your license, that you can buy through CDSPI an excess malpractice policy in the event that there would be a claim that would exceed the college's policy. Then they pay out first, and then we would pay out what's over and above the college's policy. And it's a very, very economical policy, but it is a supplemental policy. So it always follows the primary. If the primary policy deems it's not a valid claim, then the excess policy won't respond either. So we offer an extra 1 to an extra 23 million if you wish to have more than just that 2 million. So just make you aware of that it's available.
Thanks so much, Julie. Going on to Kris, can you walk us through a typical malpractice claim from start to finish?
I'll do it very quickly. So a typical claim, the dentist comes to us and says, hey, my patient came in, it was a really difficult extraction, let's say. And they left saying that they were really unhappy and mumbled about suing. We will intake the claim. We will find a claim professional who will handle it for you. They will ask you for a lot of information. We will typically very quickly, as long as it's a straightforward claim, tell you this is covered. We're going to go ahead. And then we reach out to Dianna to do a conflict check, which means she just makes sure that she can represent everybody within her ethical obligations. And then she jumps on it and starts asking even more questions and gets ready in case litigation is brought or a demand letter is received. When that happens, the dentist sends it to us immediately. And that's both Dianna and myself. I will then assess it again for coverage because we've got to see, are some new weird allegations thrown in there, like breach of contract, which wouldn't be covered. And we make sure again that there is coverage for the matter, and Dianna goes ahead and defends it. While she's doing that, I am in touch with her all the time. On our policy, it's duty to defend, which means that I become your partner in the litigation. So I'm helping guide legal decisions. I consent to all legal expenses Dianna incurs, be it expert reports, just a courier fee, whatever it might be. I have to say yes to those things. I also have to say yes to any settlement offers. And certainly, if we're going to accept a settlement offer or make one, that will then be accepted. So I'm there right until the end. And once we get it wrapped up, I end up paying Dianna's bills. I pay the portion of the settlement that's on us. We collect the deductible from the dentist, however much that may be. And then we wrap up the claim. And at that point, we have either settled and gotten a release and an agreement that says they can't sue again, they can't go disparaging you, that this is all over with and you can forget about it. And on our end, we just need to put that stuff on our file and we let you know it's all done. And that's a whirlwind tour through it. It can be completely different, again, depending on the facts of the case. But that is generally what we see with a med mal claim.
And early on, when I have my initial client call with our dentist, always say, I want to know kind of the good, the bad, and the ugly. Like if you've messed up and you made a mistake, and I've had that, I have that sometimes where our client will say, yeah, like that did not go well. I misjudged this. I should have done something different. I just, got it wrong. Like it's important that I know that early, because if there was negligence or if there was a problem with consent and our client knows it, that's not going to change later when you're under an examination for discovery or if you're at a trial. So those situations, then I may go in fairly quickly and try to settle it. Let's get it settled before that patient gets a lawyer, before this gets any further. Let's, end this early, because my duty is to the client, the dentist, to act in their best interest. And sometimes it is early settlement. And then other times, if that allegation is absolutely unfounded, and in talking with our client, we really want to vigorously oppose it, then we may take it further. There may be examinations for discovery, which are questioning under oath, but I'm always meeting with our dentist ahead of time, preparing them for it. It seems more scary than it is, but it actually can really help to settle a claim after you've been examined, because the other side gets to see how ethical and honest and straightforward the dentist is, and how they'll be as a witness at the trial, how they'll be a defendant. And then sometimes we're doing mediations, and there's a whole bunch of things that can happen before we ever get to a trial situation, because a trial is very unusual. Yeah. The other thing I just want to say about the life of a file is it's really important for our clients to know one of the best strategies we can implement to get a file settled is to set down examinations for discovery, is to set down a trial date. And when our clients hear, oh, there's a trial in 2028, sometimes they kind of freak out because they think it means it goes to trial. But it doesn't. What it means is that starts a clock ticking that will require the plaintiff lawyer to do stuff. Yeah. And if they fail to do those things, then we're in a position to try to get the claim dismissed. But if we don't get a trial date, kind of human nature, some lawyer that has 400 files, your file's just going to keep going to the bottom of the pile because it's not urgent. And then 10 years from now, you're going to find you still have this thing hanging over you. Yeah. So part of my strategy, and I think most of the defense counsel, is to get this moving along so that we can have an end date, and that will help significantly to having it resolved. The other thing is, the longer you wait, often the higher the damages will get, yeah. Right? Yeah. If the person continues to have problems. So,
and two little quick things I'll add. Number one, you got to cooperate. As a condition precedent to your coverage, you must cooperate with us and you must cooperate with counsel. If you do not, you have no coverage. And if anything happens, like you're found in default, whatever, that's on you. So always cooperate, always answer, keep in touch with us. If your counsel is writing you emails, it's for a good reason. The second thing I'll mention, as part of the policy, we have a hammer clause. The hammer clause says that we, as your insurer, may choose to settle even if you disagree. And I will tell you, I have yet to do that. Mm-hmm. I have always settled with the consent of the dentist, even when sometimes it is begrudgingly. We cannot go ahead and always get the right answer and the right outcome. We get the best outcome for you. That is my job. So I want to protect your reputation. I don't want someone running around slandering you, writing Google reviews about you that are lies, or telling people in your community that you're a terrible dentist. So if that means we have to settle early because they said they're going to make a podcast and a website and do all these things, then that's what I'm going to do. It's always in your best interest. The law says it must be, so it is. But sometimes we will say, this is the time to settle. This is the amount. Dianna has agreed that the quantum is reasonable for the injury. We must do it. And so we do. And again, as I said, everyone's always agreed in the end, because I don't think you want this hanging over you either. But just something to keep in mind if you have a claim. We can't go to trial just to prove that you were right. We can't afford that, and neither can you. So we will do what is best for you in the end.
Thanks so much. And then this is just another add-on to that question. Diana, can dentists self-represent?
I
Or
believe they
Kris?
can, but I don't think they would be covered under their
Oh yeah,
policy.
no, yeah, you lose your coverage.
Yeah.
If you want to do that, good luck to you. It's a bad choice. They always say, he who represents himself in court is represented by a fool, as a fool for a lawyer,
Yes,
right?
yes.
So don't do it. Please don't do it. I would not go represent myself,
No.
and I am a lawyer. Let us do it. This is what you pay for. So let us do
Yeah.
it for you. Now, in BC, there is the case of the CRT, which is the Civil Resolution, Civil
Resolution
Civil
Tribunal.
Resolution
Yes.
Tribunal. There, we're not allowed often, more often than not, to send a lawyer with you, but they can help you prepare your documents,
Yes.
your submissions, all of the things that you need to do. I don't think they even do any of it in person. at this
No,
point.
so what happens is I do a lot of like strata type claims
Yeah.
through the CRT and a few dental claims. Most of the dental claims, if they're smaller, they go through small claims.
Yeah.
So the way it works with the CRT is our client has to ask for permission to have a representative, and they always say yes.
Yeah.
And then us as a lawyer provides the submissions.
Yeah.
If for some reason they said no,
Yeah.
then we would just basically write the submissions and then our client would submit them themselves. We'd be kind of a ghostwriter.
Which I think has happened.
Yeah,
Yeah.
yeah.
I think at least
Sometimes we have to do that because of the timelines, just to
That
get it
too.
in time.
Yeah.
But we're there helping behind the scenes.
Yeah.
But most of our dentists' claims would be either small claims or BC Supreme Court
The limit of the CRT is 5,000.
for injury type claims, and then 35,000 for small claims, and it's unlimited for Supreme Court.
Right. So typically the claims are not under $5,000.
Yeah.
So you don't see them there.
Yeah.
But we've had a few.
A few.
So in those cases, it's so different anyway. It's just such a different setup that you're kind of representing yourself, but you're not going to be presenting evidence before a judge in person or anything like that. But otherwise, at small claims, let Diana be your mouthpiece because she has all the expertise and we're paying her. So it's in your
I
best
think
interest.
even beyond the expertise, I think when an allegation comes against a professional, it's very personal.
Yeah.
And it's very difficult to separate yourself from your own emotional reaction to that. And so that's why, as lawyers,
Yeah.
if we were sued or somebody went after us, that's why we'd want somebody else who has a more independent, cool manner about it, as opposed to representing ourselves.
Absolutely.
Awesome, thank you. And now we're going to look into claims. Julie and Kris, what mistakes make claims longer, more stressful, or more expensive?
I think we've kind of touched on this a little bit already. So one, not reporting it to your insurer right away, and offering refunds. Like, I think Kris was saying earlier, it implies guilt. So contact us right away, even if you haven't officially been sued, but something just isn't sitting right with you, or the patient was a little unhappy, or something just didn't go according to plan. Be proactive in reaching out, because at least then you can be in touch with, Diana or somebody else, and they can let you know what to do, what not to do. And if it does just fizzle and go away and doesn't end up being a claim, then we just close the file and it doesn't impact you one way or the other. So be proactive, reach out right away, and no refunds.
Yeah.
Unless your lawyer
Absolutely.
tells you to.
Exactly. No refunds without legal advice. Definitely late reporting is a real problem. If you've been negotiating, doing anything like that, like you are setting yourself up for failure. I think also non-cooperation, as I said. So if I'm fighting to get through to you, to get a phone call with you and get answers from you, if Diana is fighting to get the information that she needs, she can't appropriately represent you. And so that's one of my biggest headaches. I've been on the verge of going to the clinic to find the dentist to talk to them. The other thing is informality with your clients. Treat every patient, I don't care if it's your child, I don't care if it's your best friend, whatever. Treat them as if they are a stranger who likes to sue people. right? Because if you have them come in and you don't take notes and you just do things under the table and all of that, I guarantee it's going to come back to bite you and you won't even know who it is. I've had dentists say to me, oh, I thought they were my friend. I can't believe they sued. And in fact, I don't necessarily think that the dentist necessarily bore all the liability in some of those matters, and yet they paid because they didn't do what was necessary to defend them against the allegations. So take formal notes, treat them formally, bill them properly. If you're going to discount, show the discount.
Exactly.
Go ahead, but show it in your files. And also never tell them things like, don't worry, my insurance will pay for this, right? Don't be informal.
Yeah.
Be careful and take care of your reputation, because as a dentist, that is what you have, is what people think about you and the quality of the services you provide. And if you're running around being cute and fun with your patients, in the end, I don't know that that serves your reputation. So we have to be so careful to stay professional with them. And then after work, go be informal. But please, 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 everything, treat it as if they're going to sue you.
Yes. And I've seen that where, they're kind of friends and then they'll maybe do something at their house or at a coffee shop, or, may take a look, not taking notes. And it's really unfortunate in our litigious world. I do think it's kind of no good deed goes unpunished sometimes. So, you do somebody a solid and you have them in on a Sunday and you don't document it when you fix that tooth or whatever. That's the one that's going to come back at you, as Kris has said.
Yeah.
So I agree. And the other part of that is in terms of, I think it's also really important when it comes to websites and advertising to make sure that you are representing accurately what you do and not exaggerating and putting on your website, specialist in implants or something like that. Because if you've represented that you were a specialist, but you were a general dentist, that can be used to say, well, I went to your website and it said that you guaranteed the best results and, you have all these testimonials and all these things that made it. That's why I trusted you, and you weren't a specialist, but you said I specialize in these things. Those are the other things I see happen that can be kind of turned against people.
And that reminds me, Google reviews. Don't pay people for Google reviews. No discounts, no free cleanings, nothing for Google reviews. You can say, would you please rate us on Google? Don't say 5 stars. Would you please rate us on Google? You can put that on your reception desk, on your website, on your invoices. That's fine. But do not offer anything in exchange for Google reviews, because it's just setting you up for failure.
That is an awesome segue into our next question, which we've already touched on already, but how can malpractice claims affect licensing, reputation, and further future opportunities?
So you absolutely have to report claims. On licensing, those sorts of things, you're going to have to report claims. Now, you're also going to report, if they ask for more information, what's happening. My lawyer says this is my liability. My lawyer, will produce a report, and you can submit that to them to show that, like, we believe based on the evidence that you didn't do anything wrong, that sort of thing. But it absolutely has to be brought up. Now, beyond that, I can't say what's going to happen. You're looking at regulatory complaints, college complaints. That's where licenses are affected. I will say we have had claims where people have lost their licenses, and that's kind of separate from what we're doing in defending them on the civil side of things. But it can happen. Now, it has to be egregious, right? Like, you have to have done something so negligent that you shouldn't be allowed near teeth again.
Or a series of
negligent that shows that you are incompetent, right? That's the only way you're supposed to be losing a license. But with that said, you do have to be honest with them. That's true in all claims. Whether you're a dentist, a financial advisor, whomever you are, you must be honest with them when they ask. So when you get your renewal form, make sure you're filling it out correctly.
And although I don't represent people in college matters, When I have clients, dentists who tell me that there is also a college complaint, they're kind of like two parallel proceedings. And in the past, the legislation has been that you can't use college documents in the litigation. Yeah. There has been some eroding of that. And I see this a lot with self-reps who's like, well, I've complained to the college and they said my dentist needed to take a record keeping course. Oh, so that means I'm going to try to use that in the litigation to show my dentist wasn't doing a good job or was negligent. So I think the other thing that I tell my clients is, although it's not covered by the insurance, get counsel to help you, separate from me, counsel to help you with the college complaint. Because any admissions, if there is a citation and it's public, then once it becomes a published reprimand or citation, then that can be leveraged because it's public, it's no longer private, it can be leveraged in the litigation that I'm defending you in and used in some way to try to show that you were less than competent or you didn't meet the professional standards. Yeah. So although they're parallel and separate, it is a good idea to have counsel helping with the college matter. The other thing is that sometimes what I will do is, as long as our client gives permission, I will have communication with the lawyer on the college. So we're both going down separate rivers, but we're communicating about what's happening and trying to assist. So there's also consistency, right? Because you don't want a situation where the dentist is saying one thing to the college and then denying that same thing in the litigation. So
exactly, absolutely.
And just to point out regarding college complaints, so in BC, if you are a member of the BCDA, they do offer some sort of legal expense insurance as well. And if you are elsewhere in the country in a province where CDSPI is the primary provider of malpractice, so not Alberta, not Ontario, not Quebec, but anywhere else, there is an extension in our malpractice insurance through ARIG for legal advice and coverage, but it's only for very specific things. So it's only going to be for disciplinary hearings and fitness to practice. So you do have that little bit of assistance there if it is a college complaint as opposed to a lawsuit.
Awesome. Thanks so much, Julie, Kris, and Dianna. I'm going, just in the interest of time, I'm going to wrap up our last two questions into one. Malpractice stress can be overwhelming. What supports resources exist and when should dentists access them? And then what is one proactive step that every dentist should take this year? I'll start it off with Julie.
Sure. So hopefully you are all aware, but CDSPI does offer a member assistance program. It's basically our version of an EAP. So do take advantage of that if you do need help. I mean, life is stressful, as we've all seen through the claims here. Talk to people, get assistance, whether that's through the MAP program, whether you have component societies in your province, study clubs. You are a community, so you do have those resources available to you. And what I would suggest to everybody is review your coverage, understand your coverage, perhaps review the amount of coverage and increase that if need be. So that would be my takeaway for that.
Thanks, Julie.
My takeaway would be when you get to your clinic tomorrow, take a look at your consent forms. And make sure that if you are doing any procedure beyond a filling or some small, relatively non-invasive procedure, so when it comes to root canals, extractions, crowns, bridges, anything that is more invasive or of a surgical nature, wisdom tooth extraction, make sure you have a detailed written consent form that is specific for each of those kind of procedures, and that at the top you have a spot where it's clear we're proposing to do, extraction of these 4 wisdom teeth, and these are the things my dentist has gone through with me. These are the risks, these are the benefits, and have your patient sign that before you start the procedure, before there's any sedation, and do it with the patient. Don't give your receptionist that to have them sign. You need to the patient can review it in the waiting room, but when they're in the chair, before you start anything, you say, oh, here's the consent form. You've had a chance to review it. I'm here. I'm willing to go through it with you. Do you have any additional questions? And then also, if there's anything particular about this patient that increases the risk, let's say you're going to be doing a tooth extraction, but you know it's in the upper back molars and there's potential for sinus and involvement. You're going to make a note on there that I discussed in handwriting. You're going to write on, I discussed with Mary that she's at increased risk for this. She declined to be referred to a specialist. She declined to have a CT scan done. You want to think about that consent in a way that if the worst case scenario happens, you clearly had the communication. You can't just put had a verbal consent in your clinical notes. That's fine when it comes to a filling or something that's fairly non-invasive, but that would be my number one. If you have a really solid consent that is specific and it's clear you've gone through the risks in general and any increased risks specific to this patient, you've documented it, I'm going to be in the best position to frankly tell plaintiff counsel to go pound sand, and we're good.
Yeah. And I think really truly do the thing. Like, go through the informed consent with the patient. It's one thing to document it, but then you also have to do it. Mm-hmm. And my partner just had a whole bunch of dental work done, and I was saying, oh, did they talk to you about this and that and this? And they were saying, no, I didn't know about any of this. And I panicked them. It was terrible. One of the problems with being exposed to these claims. But make sure that you are advising them of the things related to them and their specific situations, right? The other thing I will say, the correlate to know your coverage is know how to make a claim. Know who you're supposed to email. Know what kind of information you should be sending. You can find this out from CDSPI. They can let you know what email address to send to, what information you should send with it, and that sort of thing. Create a procedure.
It's a very, very easy email address, claims@cdspi.com.
Done. Easy, right? So create a procedure for your staff, for everyone there, so they all know what they're doing. Put it on the fridge in the break room or something. Just make sure that it's available to everyone. So when things go south, because they can, you can immediately act upon it.
Mm-hmm. Thanks so much. Oh, sorry,
I just
go
have
ahead.
one final comment, and that is, remember that anyone can file a lawsuit. That does not mean that you've done anything wrong.
Yeah.
So, report it, give us the information we need. But don't be too hard on yourself.
Yeah.
If you did mess up on something, that is why you have coverage.
Yeah. And
obviously you don't want to purposely go around and make mistakes, but mistakes can happen. Absolutely. And as long as you've documented and you've done your best as a clinician and work within your scope of practice, you'll be just fine.
You're human. We understand that. We're here to help you deal with whatever comes up.
Awesome, thank you. And before we move into the questions, just one additional resource here that you should see on your screen. This is CDSPI Malpractice Resource Center, and it serves as a central hub for dentists looking to better understand malpractice risk, prevention strategies, insurance coverage, and claims management. So some of the stuff we talked about, you will be able to find educational articles in this QR code or link below. And then, yes, moving into our Q&A. Thank you so much for joining. We're going to take until the next 30 minutes or so to get to some Q&A. Also just wanted to quickly highlight this QR code that we have on the screen here. It would really mean a lot to us to hear your feedback so we can continue shaping and delivering these sessions in the future. If you could please take this short survey by scanning the QR code on the slide, we would super appreciate it. Now we'll get into your questions. So we have 55 questions. I don't know that we'll get through all of them in 30 minutes, but we will try our best. Starting off with our first one. I think this one's a great one for Julie. Are we assigned a broker, or how do we contact one?
So at CDSPI, we all work as a team. So you're more than happy to work with the same advisor over and over if you have that working relationship. But, if it's me or one of my coworkers, you can talk to any of us. We are your broker.
And just to highlight too, the difference is that we only are the primary malpractice provider in outside of Alberta, Ontario, and Quebec.
Mm-hmm.
The next one here is if you work for a corporation, should you use their in-house counsel or obtain independent counsel?
Obtain independent counsel, period, end of story. You have your own independent insurance. If you want us to pay for it, certainly you're going to have to go through us. But generally, this is one of the trends I've been seeing is that as venture capital corporations buy up dental clinics, there are adversarial issues between the clinic and the dentist. And sometimes the clinic will put more liability upon the dentist than is rightfully allocated to them. And the clinic can have vicarious liability for your actions. And if they do, then your insurance policy should cover that part of their defense. But there's often independent allegations against the clinic. For example, they weren't hygienic. The receptionist said something discriminatory. Another employee caused me a problem, whatever it might be. And where there's independent actionable wrongs against the clinic, they got to pay for their own defense. And if they want to use their own counsel, that's fine. But I think it creates a conflict of interest when they are representing independent contractor dentists within the organization. So report it to us and get your own counsel. It will not hurt you. We work with them. We'll be lovely with them, right? Like we don't want to make your life difficult. We don't want to harm your employment relationship. And at the same time, it is our duty to protect you. It is not necessarily their in-house counsel's duty to protect you. It is their duty to protect the clinic.
And the other thing, of course, is that a corporate lawyer may not have the expertise to defend this effectively.
Absolutely. Yeah, they're not a litigator necessarily, and we have a litigator, so let us litigate for you.
Thank you. Next question. What happens if you don't sign off on any entries? Often notes are done the next day.
I don't think generally that's a problem. It's late note taking, right? Or it's trying to go in later and add or change things. So generally speaking, where I've seen problems is, the complication happens, the person leaves the clinic finds out 2 weeks later the person had a massive stroke or something, and then the clinician goes, oh shoot, I didn't document the treatment at that day, and then they go in and put it in. That just doesn't even mean that what's put in was incorrect or false. It's just, it looks like they went and tried to backfill it. So just the sooner you can document, the better, because the courts look at notes that are contemporaneously made as being the best evidence. So if you made a note about what happened way before you had any anticipation of litigation, and then you signed off on it and it's locked in the system, there's no reason for the court to think that you would have been untruthful in making that note, because why would you? You didn't know this was going to turn out the way it did.
Thanks. This next question is, what if there's no malpractice or misdiagnosis, however, there is a problematic patient? You offer them a refund without prejudice basis. Can they use it in front of a judge?
I mean, without prejudice, it doesn't have a lot of teeth generally, right? Like if you're just throwing it out there, if you haven't gotten legal advice, don't offer a refund.
Because there's ways that it can be worded on a without prejudice basis for a refund. And I would on behalf of a client, offer a refund on a without prejudice basis, but require that they sign a release that they will not pursue any litigation based on that refund.
And the release, we have to be so careful. So the courts, and rightfully so, look at the relationship between the plaintiff and the defendant and say, where's the power in this relationship, right? And so, for example, the employer has more power than an employee. So they'll be more generous to the employee. It's the same thing here. The dentist is the expert, and the patient is in their care, vulnerable, right? And so if the dentist then says, well, in order for you to get the refund for the horrible thing that I've supposedly done, you must sign a release, that release better be legally solid, not this one that, you know, just floats around that necessarily covers every single possible, you know, situation. It needs to be tailored to the circumstances. It needs to be as careful as possible. It can't be overreaching. Otherwise, the court's going to throw it out. And then you're in real trouble. So again, legal advice, we pay for it. This is what you pay for with your insurance. Get the legal advice. And then if we decide a refund will settle this matter, we'll do it. And Dianna will draft a release.
Exactly. And sometimes we're doing it behind the scenes and the patient won't even know that there's a lawyer involved.
Yeah, there's a lot of ways we can make this work to keep your relationship with the patient and to keep your reputation strong.
Thank you. Next question. Are scanned notes considered official? I was under the impression that any documents scanned are not considered legal documents unless they are accompanied by the original paper document.
No,
I don't think so.
Not at all. Not true. No, scanned documents are fine. Yeah, absolutely, because it has that timestamp and you can tell if it's altered. So no, that's fine. I mean, if there was a fire and you lost all your documents, right?
Yeah.
A lot of companies actually are paperless, and that's exactly how they do it. And actually, a lot of law firms as well.
Right.
So no, that's perfectly fine. You do not need to maintain the paper document, but dispose of it properly for privacy reasons, right? Take care of that. It is health information, and so the highest level of privacy protections. But no, that's fine. As long as you're scanning it, keeping it in a secure file in a secure computer, that's fine.
Mm-hmm.
Awesome. And then on that topic, in electronic charts, how does the court confirm there was a consent to treatment? I ask and I write there was verbal consent, but a patient doesn't sign.
Well, you need to have a paper consent form that you present to the patient. Typically, it's given to them at reception or by the dental assistant. They've got it on a clipboard. They have a chance to review it. They have time to read it. Then you come into the treatment area and you say, hey, I just want to go through the consent. We're looking to do this today. I'm going to just quickly go through these with you. Have you had a chance to read this? Do you have any other questions? Oh, and by the way, these are the specific issues, you know, with respect to you that increase your risk for X, Y, and Z. And then you have the patient sign it and the dentist signs it and dates it. And then that's the kind of thing that would be scanned into a chart or kept in a paper chart.
And if you make that your policy, that you're always doing it, you can say, I always do this on every single file. Here it is. I have it. If you're doing it in reception, you can have the receptionist there to witness it, which is helpful. So they could say, every single time we do this, this is our standard policy, and that bolsters your credibility.
Thanks so much. We talked about this already, but I think there's no harm in just reiterating it a little bit. Do you recommend malpractice coverage for admin staff or just clinical staff?
Well, just to step in there, the malpractice that we offer is just for dentists, hygienists, dental assistants, dental nurses. We don't offer for administrative staff.
Thanks, Julie. Let's see, here's another question. If someone sues in small claims court and you win the case, can we get reimbursed for lost clinical time by insurance or from the patient?
By insurance, no, that's not something that we cover. It's a shame, but it's part of the profession.
Thank you. Another one here. I guess we'll go speed round if we can. I am an associate dentist and I have not completed the associate agreement. If a patient is suing my associate dentist and also includes me, will I be liable to pay and will malpractice cover me?
As far as coverage, if you are named in a dispute, you're likely going to have defense coverage. It depends on what the dispute is about, of course. If you're named in an assault case, maybe not, or a criminal case or fraud or breach of contract. But if you are named on a claim about negligence in the practice of dentistry, then yes, and then we get you out if it had nothing to do with you. If you had some involvement, you saw the patient after, for example, or you helped them with something and then traded off to the other dentist, whatever that might be. You may have some involvement, but as long as you're named on a demand or you're named on a lawsuit, we can assess you for coverage.
And sometimes I will represent both the clinic and the associate dentist, but where they are adverse in interest, where there will be a potential conflict in the evidence between the two, or if the relationship isn't really good, then what happens is I will keep one client and the other will go to external counsel. That kind of goes back to that whole issue about, the corporation, right? Whether a dentist would want to have the dental corp lawyer represent them. That's all fine if everyone's on the same page. The problem is when one of the parties wants to throw the other under the bus, right? So going back to that associate contract, if you have a contract saying you're an associate dentist, you're independent contractor, you're responsible for your own professional conduct and decision making, and I'm not supervising you, that helps the clinic, right? Yeah. But absent the contract, it could be inferred that the person was some type of, in a supervisory position or somehow deemed to be an employee or something like that.
Exactly.
For sure. And another question, how long does a patient have to make a claim? Like how many years after multiple post-surgical consequences?
So with medical negligence, it's a little different than like if you had a car accident or if you had a slip and fall. If today I leave the office and I have a slip and fall, I know I was injured today. And then in BC, which I believe is the same across all jurisdictions in Canada, I have 2 years, which is a very hard limitation date. So I have 2 years from the date of the injury or the negligent situation to file a notice of civil claim. If I do not, I lose all opportunity to file a claim. But in medical negligence, dental negligence, there is an added issue of the date of discovery. So that clock only starts, the limitation clock, the 2 years, only starts ticking the moment the patient discovers or ought to have discovered that negligence happened. So sometimes you can imagine, dental claims, it's going to take some time before the person realizes, ooh, that implant that I got that then failed 3 times, that was negligent. So the time allowed is often more than 2 years, because unless something horrific happens in the dental chair on that day and the patient loses confidence in the dentist and questions that there was negligence, that clock doesn't start ticking immediately. The other exception is with children. Or so if you are if you're providing treatment to a child, it is 2 years after they become an adult. So going back to what was brought up earlier about retired dentists, conceivably a dentist on the verge of retirement could provide treatment to a child who's like 10 years old, and then 10 years later, because it's age 18 or 19, depending on your province, plus 2 years, they could have a claim against them.
Here's another one more about the consent forms. Should consent forms document estimated costs, or can cost estimates simply be documented in clinical notes?
I don't typically see the costs in a consent form. The purpose of a consent form is not about outlining a cost estimate. It is about ensuring the patient is well informed of the risks and benefits, alternative treatments, the option of do nothing, and anything specific about them that makes them at a higher risk than the regular patient.
Thank you. Then going back a little bit, because we talked a lot about no refunds throughout the panel session. How about not charging a patient for a procedure where you did not have a favorable outcome? Does that count as a refund?
Charge it and then do a courtesy discount.
Yeah. Courtesy discount is better. Totally giving the money back is telling.
Yeah. And then on the refund front as well, we had a similar question to this, but what if there was a final release provided when the patient is not threatening a lawsuit? Does that have any stand in court?
I think if it's a well-written final release, it's solid, it's good.
Yeah, as
They
long
don't have
as
to
it's
threaten, they don't have to threaten a lawsuit.
No, it just, the question is the release sufficiently tailored to this circumstance? Will it stand up in court? And a generic release written by ChatGPT will not. I will say that up front. Will one that's supplied by a college somewhere stand up? We don't know. It depends on the circumstances, right? But it's better than none.
Yeah. It shows that the person contemplated that they were not going to pursue litigation.
Yeah.
But for example, sometimes my clients want me to include in the release that the patient will not pursue a college complaint.
Yeah.
I will never put that in a release because that is too far reaching.
Yeah.
A college regulatory matter is different than litigation.
Yeah.
And so as much as I'd like to put that in, it would probably deem that release unenforceable.
Yeah.
Thank you. Switching gears a little bit, how does coverage work when moving to a different province? What if legal action is required after leaving the former province and malpractice insurance is only active in the new province the following calendar year? I have to move every few years because, yeah, I'll just leave it there.
So if you are moving, like was mentioned before, we are the primary provider across the country with the exception of Alberta, Ontario, and Quebec. So if you're moving, you just need to let us know so that we can then confirm your license in the new province and therefore add it to the policy. With regards to if a claim arises afterwards, in the industry, there's two types of malpractice policies. There's claims made and occurrence-based. Ours is claims made. So it is the policy that's in force at the time of the claim that will respond to the situation. So if you are in, BC and then you move to Manitoba, that's fine. You still have active malpractice insurance, even if there's a claim that arises from BC.
One thing
Thanks,
that's really
Julie.
important is just that you're licensed at the time the work was done in that province, right? Do not do any work while you don't hold a license in the province that you're in. And I don't imagine anyone here would, but I'm just going to say it.
Thanks, Kris. And this one, I guess, could be for anyone too. Can a dentist buy CDSPI/malpractice insurance if there is a claim under investigation already?
Like retroactively?
That'd be
Yeah,
bad.
which
Not
is kind of, there's an answer here.
If there's open claims, then we have to go to Zurich to get approval to increase the coverage. So depending on the circumstance of the claim, is whether they will approve the increase in coverage. But yeah, depends on the situation. But you can increase coverage. We just need to run it by Zurich if there's an open claim.
Thanks,
Yeah.
Julie. Because yeah, malpractice and your license go hand in hand. Let's take a look here. Do you need to advise patients about possible nerve damage with LA?
Yes.
Yeah.
One of the biggest challenges we see is something goes wrong and the dentist doesn't want to tell the patient something went wrong. You need to tell the patient, you know what, you jolted a little bit when I was putting in that anesthetic. I think there's a possibility we've touched the nerve. This is what you might happen. This is what you should expect. And if there's anything that needs to be done to mitigate that, monitoring, I want you to come back. I want to give you, some anti-inflammatories or some other, meds. You need to do everything you can to manage and minimize the complication. Not telling your patient is not a good answer.
And beforehand, I mean, if you're just filling a cavity or something like that, you don't necessarily have to have an informed consent form.
Yeah.
But you can let them know. I think it's you don't want to scare your patients.
Yeah.
So it's the balance of not scaring an anxious patient and being honest with them about what could happen. Because if you have this happen to you and your nerve is affected, like it's serious.
Yeah.
That can be really, really bad, depending on the severity of the injury to the nerve. So better to over-inform without panicking than under-inform, and then later they have a valid claim against you for not informing them of the possible risks of the treatment.
Now, that doesn't mean that you're supposed to inform a patient of every risk. You're not going to say, well, there's a 1 in a million chance you're going to die. Like it has to be beyond a very rare complication. But there would be, like, if you were doing just a regular local anesthetic, I probably wouldn't go into the whole thing about nerve injury. But if you're going close, doing a nerve block and you're getting close to the IAN nerve, and you can see in the x-ray that, the IAN runs high or is close to your root, it would make sense to inform the patient and then document that I had a conversation with the patient that it's a rare, but they're higher risk because of the location of their IAN nerve. Not possible to see the exact location on a standard x-ray. I offered for them to go for a CT scan with a specialist if they wanted, but they declined. And then if there's an actual nerve injury, to document it and refer on to specialists if you need to. Don't hide from patients' complications.
Yes.
Thanks. And then I guess on that note, what if a patient refuses x-rays or treatment or something like that, and then later a complication arises? Is a standard release form adequate? And is there any liability on the dentist if the patient just refuses to accept the dentist's recommendations?
Well, I mean, you have to document if the patient doesn't want the x-rays, but if a patient is asking for a treatment that is not appropriate and is likely to lead to harm, like anything, like if you had a patient come in and said, I just really don't find my hand useful, I'd like you to cut it off for me, you'd say, well, that's not a good idea. And you did it. I mean, obviously that's an exaggeration, but like I've had situations where we see files where a patient comes in and says, you know what, I don't want to bother with these teeth. All my teeth are going to fall out anyways. I'd like you to clear my mouth.
Yeah.
Like before you go ahead and do that, you better make sure it's been a fulsome discussion and that you're not pulling out viable teeth just because the patient says that's what they want to do.
Yeah.
If I was a dentist, I would refuse to do something like that.
Yeah, absolutely. And document.
Yeah.
Right. Document that you talked to them about it. Document that you recommended certain ways to look at the situation, like x-rays, things like that. Document that they refused, and then think really hard about whether you should proceed or not.
Yeah.
Really hard, because if you turn someone away because you think, and based on your training and based on the things that the college has told you to do or not do, you believe that it is the wrong thing to do, then you can refuse treatment.
Yes.
There's a possibility that they'll sue you for failure to treat. Of course, there's always a possibility. But if you
will not succeed.
That will not succeed. Oh yeah. No. And that's what you have insurance for. But if you fail to treat in a situation where that was the right thing to do, it's not failure to treat. It is your ethical obligation to the patient.
Yeah.
Great. Thanks so much. And then we might have touched on this already, but how long does a claim take to get resolved on average from what you have seen?
A year or two for the smaller.
Yeah.
For simple ones, I think most we can settle pretty quickly and get rid of, or sort out. So 1 or 2 is probably the most common amount of time. But then there's others that go on for decades.
It also depends on the plaintiff counsel that we're dealing with and whether or not they're moving along. And that's what kind of circling back to what I said before, where we often are really like pushing to move the file along, making demands for document disclosure, setting down applications, demanding that they produce the plaintiff for examinations for discovery, setting down trial dates, because that is the way to move a file along, not just sitting back as defense counsel.
Absolutely. And I find that especially the more egregious plaintiff counsel who are taking on every single file don't have time to deal with these files. And that means they end up dragging their heels because they can't talk to you on the phone about what's going on. They can't set up a mediation. They're not thinking about any of that, right? They can only do a few files at a time on their desk, and yet they have a pile. That can delay things as well. So depending who your plaintiff counsel is, if they're a good one, you can get things wrapped up quickly because that's also in the plaintiff's best interest. If it's not, if it's one of these ones with bus ads, that can take longer. But we're trying. The nice thing about having your insurer provide your defense is that Dianna can have a high level view of so many claims at one time, and we can notice which counsel are a problem and then act as a united front across all of the claims for which they are plaintiff counsel. And then we can put significant pressure on them to start behaving properly. So there's been a few situations where we are utilizing that as a pressure point and as a way to monitor these claims and get them done faster and to get these plaintiff counsel to stop bringing claims. So that's huge.
Yeah, and I would say just clearly non-viable claims.
Non-viable, absolutely.
Like, legitimate claims. If we assess something, sometimes I'll get an expert opinion, kind of verbally, and if it looks not good, and we know, we will settle it, and we will recommend paying the money to get it done because that's what's in our client's best interest.
Exactly. Yeah, we're not out to steal money from vulnerable patients who should be paid for their suffering. I think that's one nice thing about my job is that I can ensure that where something has gone wrong, they will be compensated fairly. That's also Dianna's job, ethically, her obligation. So, we'll put them to bed if that's the right thing to do. And if it's not, we push forward and get expert reports and all that.
We are at time, so a big thank you to all of our panelists. Just as a note, of course, all of this is constituted as educational information. It is not legal advice. That is for your personal situation. So if you have any specific questions, please reach out to us at CDSPI or Kris and Dianna. And thanks again for joining us this evening, and have a great night. Thank you.